Great. Thank you so much for coming. Thank you for being here today. Thank you for those who are on Twitter and tuning in today. I'm really excited. My name is Tanuja, and I am a program manager at Google, and we recently had a little bit of a walkout that you may have heard of in November, where 20,000 of us walked out in protest of how our company was handling sexual harassment, discrimination, pay inequity, and a slew of issues at the company. And a week afterwards, we had some changes in arbitration policy, which we'll talk about what they are and why they weren't enough, and why we're continuing to fight. So today, I want to talk a little bit about what arbitration looks like in America and where we want to go. So with that, why don't we do introductions down the line? And Professor Gillis, if you want to kick us off.
Hi, I'm Mary Gillis. I'm a professor of law at Cardozo Law School, just a couple books away. Thanks for having me.
And I'm Catherine Stone. I'm a professor of law at UCLA School of Law.
I'm Alex Tallman. I'm interim dean and a professor at Cornell's ILR School.
Jason Fewman of Dwyer and Bernstein. We're here in downtown Manhattan.
I'm Galen Sherwin with the ACLU.
Wonderful. Okay, so let's talk a little bit about what is arbitration. Professor Colvin, your study with the Economic Policy Institute is probably the most cited. So for those of us who are not lawyers on this panel, myself, and everyone watching, can you talk a little bit about what it is?
Sure, it's one of the confusing things that we use this term arbitration, and yet often people aren't familiar with what it is. And that's actually one of the problems with this, because it's going to turn out that people are signing contracts to do arbitration, and they don't know what arbitration is. Arbitration formally is any kind of process where you hire some person, a neutral person, third-party neutral, not the person you have a dispute with, to resolve your dispute. You've got a dispute with your neighbor over a fence. Is it on their property? The arbitrator is a neutral person, is supposed to come in and decide who's right and who's wrong. Simple enough. But it's going to get more and more complicated. Firstly, you might wonder, well, what does this actually look like in practice? How's this like the courts or not like the courts? One thing I understand is it's not going to look like Law and Order. Right, our general image of the courts with very formal objections and all the formal rules of court. Arbitration tends to be a more informal process. It's a private process. You're not going to have the public there in the audience the way you would in the court. What it actually looks like is something that many of us have seen, and that's Judge-Judy. We will admit it, but many of us have watched Judge-Judy. And Judge-Judy, if you take off the robes, is actually arbitration. Actually, legally, it is arbitration. The participants in Judge-Judy signed an agreement that Judge-Judy will serve as the arbitrator to resolve their case. But Judge-Judy is actually a useful metaphor for understanding arbitration, because if you think about it, it's a show where the decision maker, the judge, is resolving things in this kind of very informal way relative to what we'd expect of the courts. She's intervening, she's questioning, doesn't follow the rules that we would follow in court. That's what an arbitrator can do. Now, if you have a good arbitrator, that could be a good way to kind of get to the real heart of a dispute. On the other hand, if you don't have a good arbitrator, that could be really unfair. You may be losing the rights that you'd have in court. Right? So that's where we get into the tricky issues about arbitration. And arbitration works well in some settings. It's got a long history in the commercial setting in some industries, construction, insurance. It's got a really successful long history in the unionized setting. Organized labor, unions negotiates contracts with employers. Those contracts almost always include an arbitration clause where an arbitrator will resolve the dispute, any dispute involving the contract. And that works pretty well because it's negotiated between two equal parties and the unions there representing the workers. What about forced arbitration? Right? That's the term we talk about, forced arbitration. What does that mean? Well, forced arbitration is where you end up in arbitration and you didn't really have a choice. This is something we've actually all encountered. And take an example, the cell phone. Right? If you've got a cell phone, you've got a contract with a cell phone provider, Verizon, AT&T, Sprint, whichever company. There's those terms and conditions you clicked, and you spent the 5 seconds I spent looking at them before clicking I agree. In those terms and conditions, there's an arbitration clause. All of them have an arbitration clause. right? You agreed to arbitrate any dispute. If AT&T was ripping us off $25 per year per contract, that dispute, if we wanted to sue them, we couldn't sue them in court, we'd have to go to arbitration. And that is in there, right? You have agreed to that. Turns out you've also probably agreed to that in your credit card contracts, and a lot of you will have agreed to it in your employment contract. And you may not remember this, because a couple of years ago, when you were being hired, they made you sign a bunch of stuff. You were asked to sign the employment arbitration agreement. That's a forced arbitration. You get no choice. If you don't agree to it, you don't get the job. Right? That's why we call it forced arbitration. It's way before you ever thought you were going to be subject to discrimination or sexual harassment in the workplace. You know, that's something that normal people don't think of as something that will happen on their job when they're taking up a job. You don't think, oh, I'll take this job, and yeah, maybe in a couple of years my boss is going to sexually harass me, right? Normal people don't think that way, right? And so you signed this agreement way in advance because you had to get the job. Now you're stuck in arbitration. And the question is it going to be fair or not? And we've started to get increasing evidence that it's really not going to be the same as going to court. You don't get as much damages, you don't have as high a chance of winning, and there's other specific things we'll talk about that are pretty unfair in some arbitration procedures. And you don't get to write the arbitration procedure. The company writes it. That's the real problem here. You're just being required to sign on to it. This has been a growing thing too. That's the last point that's really important to recognize. I've done a series of studies over the years. I did some back in the 1990s. The 1990s, maybe 6-7% of workers were covered by this. By the early 2000s, I did a study in 2003, maybe 20% or so of the workers were being covered by this. I did one about a year ago that found that now over half of private sector non-union workers are being required to sign arbitration agreements. All kinds of companies are doing this in all kinds of industries. It's really widespread across the company, and most people don't realize they've signed it, right? Until something bad happens at work, and they think they're going to sue the company, and they discover they can't. They go to a lawyer, and they're going to find out that they can't go to court. And that's why this is a really big deal. It really affects a lot of people's rights.
So if a company breaks the law, I can't sue them. I have to go to Judge-Judy. And who can be a Judge-Judy? Can I be a Judge-Judy?
You can be a Judge-Judy. I can be a
That is
Judge-Judy.
really-
I actually don't do that because I think that would be kind of a conflict of researching that and actually doing that on the side, making a little money. You know, and there are arbitrators out there who are really good, genuine third-party neutrals, right? And in the labor arbitration realm, we've got a lot of people we've had doing this for years and years, and they're respected by both sides. But the problem is that's not the only people who can do this. Anybody can do it, and they can write in the contract, right, that you're going to use a certain arbitration service provider that will come up with some arbitrators, right, and you don't know who they're going to be. And the danger is that you can be in front of somebody who's not really as neutral as you would like, or not the person who you think would be appropriate to decide the case.
Got it. Okay, so now I'm glad you brought up, this is a really loud mic. Okay, now what we've seen, as you said, it's growing. It's not just me against a company. Now there's also these class action bans that are in our agreements. Professor Gillis, can you talk a little bit about what you've seen over time and how arbitration clauses have grown?
Right, so I completely agree with everything Professor Colvin said, but I guess I'd add this one sort of gloss on it, which is that one of the reasons that arbitration sort of remained niche-y, right? It was used in construction and insurance and labor. It's because the idea was that, you want to have an expert arbitrator try to resolve a dispute between two parties who want to sort of stay in pretty good relationship with one another. They in fact want to continue to do business with one another. And they're going to trust this expert arbitrator to kind of resolve their dispute so things don't get ugly. And so arbitration actually, in that setting with two entities who come at it from an arm's distance and who negotiate forward pre-dispute, but maybe with an understanding of what those disputes look like, that makes sense. But now we're seeing arbitration being used in standard form agreements and used against consumers and employees who have no knowledge of what they're signing, are often signing these things, as Professor Colvin said, in order to get the job, in order to get the phone service, in order to get whatever the amenity of modern life is that we all need, and the arbitration clause is what's between us and that amenity. And the reason companies are now so interested in using arbitration clauses, and the reason we're seeing them proliferate, is because they also ban class actions. So it's not just you have to go in front of this independent neutral that we choose and the procedures we decide upon, but you're also required to do so individually, one-on-one, solo. So let's think about what that means, because we all might think, I'm an independent person, I can go into an arbitration independently, but if you do have the $25 claim that Professor Colvin described, right? AT&T has charged you $25 over the course of a year, and you believe those charges to be illegal. You didn't incur those charges, you don't understand those charges, you get nowhere with customer service. I don't know if you've tried customer service, you will get nowhere with customer service. Are you really gonna arbitrate that claim individually? It's gonna cost you so much more to arbitrate that claim individually than $25. So you're not going to do it. Now, in the world of class actions, which I know can get a bad rap, this is what would happen. A lawyer would bring a claim on behalf of all consumers who had been charged that illegal fee. And that's how the little guy can go up against the big guy like AT&T, right? And so class actions serve this incredibly important purpose of allowing collective action to happen and enabling people to come together to be able to vindicate their rights. This is incredibly important in the consumer arena, right? Because unless you really believe in the market will solve all problems, litigation can serve an incredibly important corrective, right? Can make companies much more conscious of wrongdoing, much quicker to resolve the wrongdoing because they don't want to have to deal with the class action. But I would argue that class and collective litigation is even more important in the employment arena. Because if you're an employee who has suffered sexual harassment or wage theft or any of the myriad things that can go wrong in an employment relationship, it can be very frightening to go out on your own, put a target on your back, to arbitrate a claim individually. And for some kinds of claims, like systemic discrimination, it's actually impossible to prove those claims on a one-off. You need to have people come together to also tell their stories, to talk about their experiences. And it's also probably important for the employer to understand what it looks like to work in these spaces, to understand who's engaged in the wrongdoing so they can fix the problems. So there are tons of stories. And we were just talking about the case of Sterling Jewelers. I don't know if any of you know the story of Sterling Jewelers, but it's a company, it's a sort of a, think of it as a mall jewelry store. For about 2 decades, the female employees of Sterling Jewelers were routinely groped. They would go to client dinners where they were sexually assaulted. They were expected to have sex with their clients, with sort of high-rolling clients who bought a lot of jewelry. And this was at the managerial level, right? It never sort of rose up to the level of the president of the company, allegedly. We'll never really know the truth of this. And each of these claims was shunted into private arbitration. And it went on for years, and apparently went on all around the country at different stores for years, until finally a female employee came forward, sort of breached her agreement to arbitrate, to sort of tell the story of what was going on in the Sterling Jewelers stores. This happens probably all the time, right? Because if cases continually are sent into private secret arbitration, where there's no written record, right, where we don't know what happens from one arbitration to the next, things can be going on in an employment sphere that none of us will ever know about, right? You could be working next to somebody who has actually suffered terrible acts of discrimination or wage theft or something else, but you would never know, right? And the company's bigwigs have no real incentive to fix systemic problems. So I think class and collective actions are lost in a world where we're enforcing class banning forced arbitration clauses. And I think that's an incredibly important thing to focus on in this discussion.
Yeah, absolutely. The Sterling case, just to give a sense of scope, it's 69,000 women across the country, and they've been in arbitration for 11 years at this point, still going. So, that's a good segue actually, because Google's walkout was in November, but tech is a young industry, it's finding its legs in a lot of way. But Galen, I wanted to turn to you a little bit because you've been fighting this for a while, and you shared some stories about what you saw, I guess, in the 70s Or the 90s.
90s.
Sorry, I did not mean it. I'm so sorry. Do you mind sharing a little bit?
Yeah. Birthday, 1972. So.
I'm sorry.
I'm not ashamed of my age. Yeah, so no, I have been involved in advocacy around forced arbitration since the 1990s, and sort of it was prior to my putting on my lawyer hat and going to law school. And I was working with a number of women who were involved in a lawsuit against Solomon Smith Barney. And the case stemmed from allegations that there was a basement room in the Garden City branch of the brokerage firm where male brokers would party, including inviting strippers and any female employee who ventured into the room sort of at her peril. Women were groped. The lead plaintiff was kissed on the lips when she went down there against her will. And sales assistants and brokers came forward to tell similar stories about conduct occurring there and at branches across the country, including one woman who was actually raped in her office. And so the allegations were really quite severe and very common across the women. They also included allegations of sort of tap on the shoulder hiring practices and unfair systems for passing along the books and deprivation of training opportunities for female sales assistants. One woman said that she had the training books basically handed to a less qualified man right in front of her when she'd been asking for those. She had a test that she had to take. So those types of claims, and those women brought a lawsuit, and it was a class action lawsuit, and they immediately faced a fight to stay in court because at the time, all brokers and people in the financial services industry were required to sign a form called the U4 form, which mandated arbitration in front of a financial services-oriented body that was charged with handling mainly disputes between brokers and clients, so financial disputes between brokers and clients. And that was the type of sort of industry expertise arbitration that was very common. But this kind of body was not familiar with sexual harassment, with employment discrimination, and was mainly the people who were involved as arbitrators were people who had come out of that industry and were themselves predominantly older white men. So as you can imagine, the women did not want to end up in front of that body. And there was a similar case that came out of Merrill Lynch with very similar allegations around the same time. So both of those cases ended up settling, but really did start the public conversation, I think, about the potential for unfairness in these arbitral forums and the need to be able to tell stories in court in order to, like Dr. Gale said, expose systemic problems of sex discrimination in the industry. And as a result of that advocacy, the financial services industry, the SEC, did change its rules and stopped requiring brokers to sign the U4 form for employment discrimination cases. How did the industry react? It just privatized this. It made every single person at every firm had to sign a form as a part of their employment contract. So it was no longer part of the financial regulatory system. It was now firm by firm, but every firm essentially adopted that practice. So it has not stemmed the tide there, and you've now seen it extending into bans on class actions. And so fewer and fewer of these types of cases are coming to light. It has a real stunting effect on the law, on the development of the law in this area, because so many cases are now being channeled into this private forum where the results are usually, the process is confidential, the results are confidential and secret. You don't ever find out what has occurred. And the decisions they're not bound by precedent, nor do they create legal precedent. So you have this real stunting effect on the development of law in this area. And sort of concurrently, the case law in the Supreme Court has extended the reach of enforceability of arbitration clauses sort of far beyond what I think most people would think is mandated by the federal law called the Federal Arbitration Act. And the language of that act, you would think creates, if you read it based on plain language, you would think that it creates an exception for employment contracts. It says contracts of employment. But the court has held that, nope, that's not what they meant. They meant contracts of employment as relates to this particular subgroup of employees, transportation workers. So there has been a real extension of the reach of the enforceability of these contracts and real deference to the contracts. Courts always basically enforce them. So for that reason, it leaves folks with not that much that they can do about it. We are left fighting employer by employer, advocating with our own employers to try and get them to agree not to include arbitration clauses. And then, of course, regulation or legislative change. Now, again, the Federal Arbitration Act preempts any attempts of state laws to overcome or to prohibit arbitration clauses, for example, in particular types of contracts. But there are some creative solutions which others, I think, on the panel will speak to.
So let's say, for those who have arbitration in their contracts right now, to your point of kind of how it's stifling and the challenges you'll face, Professor Stone, I'd like to turn to you. Can you tell a little bit about what I should expect as I go into arbitration? What are the difficulties I'll face?
Yes.
Is this switch you out, Mike?
Oh, okay. Yes, thank you, Tanisha. Thank all of you for coming. I'm just so delighted to see so much interest in this issue because it really has been under the radar screen for a long time, and it's now, and thanks to the Google employees who have been so active in bringing this to public attention because it's such an important issue. Now, there is no one off-the-rack arbitration procedure. Arbitration is said to be a matter of contract, but as Alex explained, it's really a contract that the employer or the manufacturer will make and impose on the employees or the consumers. So, but nonetheless, the arbitration clause itself may contain some procedures that will then be applied, but if not, it's up to the arbitrator. So the individual arbitrator is basically master of the proceeding in every regard. Nonetheless, there's a few things that you give up that you may not realize you give up. So you give up your right to a jury trial. If you have arbitration clause, you give up your right to appeal if you feel that the result was unfair. You give up your right usually to any kind of discovery to find out facts before you actually get to your hearing. You might give up your right to punitive damages depending on what's either in the clause or what the arbitrator feels is appropriate. You may give up your right to a neutral decision maker. Some arbitrators actually have long-standing ties to the companies for whom they arbitrate and get their bread and butter from those ties. Often you give up your right to learn of others' cases because, as was said already, many arbitration agreements have confidentiality provisions either in them or get imposed in the course of the arbitration proceedings, which prevent you or others from talking about their cases, so you can't find out who has had similar experiences, and that can both hinder you in bringing your case or in winning your case, because very often people, when they have problems at work, even harassment problems, as we know, think it's their own fault. And if you haven't heard from others, you often don't know that in fact there's something you can do to remedy the situation other than quit your job, which was the remedy that many people took for a very long time. So you give up a lot of rights in arbitration, and these rights are actually meaningful. They actually affect whether you can win your case or not. So just to give one quick example, many of the cases that have been mentioned and that do come up at work involve employment discrimination. And if you feel that you've been discriminated against on the basis of race or gender or age or disability or ethnicity or whatever, in order to win your case, you have to show that you were treated differently than others, and that the reason you were treated differently than others had to do with this, your characteristic, whether it's your race or your age or your gender. And to do that, to win, you have to show that, But to do that, you then have to know how others were treated, because you have to be able to show that when an employer, let's say, disciplines somebody harshly or fires him unceremoniously, they'll always say it's because you came in late, or because you've been absent too often, or they'll give a reason. That will be often a pretext, a fig leaf, which is hiding perhaps a biased reason. But you can't prove that it was biased unless you can show that nobody else has ever been fired for coming in late, or nobody else has ever been fired for absenteeism, or nobody else with your record has ever been fired. You know, you've been absent twice in 5 years. Whatever it is, you need to have a baseline to show that your treatment was different than others in order to win your case, and you can't get that without discovery. And that's why it's important in litigation to have discovery in these employment discrimination cases, and you can't get that in arbitration. And without that, you can't win. So that's just one example of how these seemingly obscure procedures actually affect the outcomes of the cases.
No, thank you for that. I think one of the other things, kind of building on what you just said, is having a lawyer that can help you navigate this process. Even though it's billed as something that's simpler, fairer, and faster, it's none of those because of the reasons that you just mentioned. So as a lawyer, if I come to you, what kind of goes through your mind as you're looking at a case and evaluating if it's worth taking?
Sure. So I think first and foremost, the facts of the case itself, right? When somebody comes into your office and you interview them, you find out exactly what it is that happened to them. You certainly, first and foremost, that's the first thing that you talk about. But then the next question that you ask is, do you have an employment agreement? What does your employment agreement look like? Have you agreed to go to arbitration as opposed to going to federal court or state court? Because as Professor Stone touched on, there are so many limitations placed on arbitration, that you may not be able to get to a number of facts that your client is actually telling you happened, right, to them, because you're not going to be able to get to some of the individuals that may have been there. You're not going to be able to take as many depositions as you would. JAMS itself, just by way of example, just touching on something Professor Stone said. The Arbitration Mediation Service, which a lot of the arbitrations end up going through that come through employment context. They allow one deposition, right? So one chance of getting somebody from the other side that you're going to be able to question about all of the facts that you're going to need to bring into your case to prove exactly what it is that your client is telling you, to prove the disparate impact, the wage claims, the discrimination claims. And in federal court you get 10, right? 10 bites at the apple, 7 hours each. I mean, the discrepancy is so wide, and the birth of how you can get that information is so narrowed in the scope of arbitration that it really does impact some of the the things that you think about when a client ends up coming to you. So and then you would look at the context of the arbitration agreement itself, right? Is somebody going to, am I going to be able to bring this to federal court? Is there going to be a motion to compel to bring me back to arbitration? Do I have to pay for that? Everything is really confined to that document itself. So that really is the most important thing that you're going to end up looking at. Can I get damages? Can I get punitive damages? Who pays for the attorney's fees? So a lot of those things go into the soup, I say, right? You sort of throw this into the soup and you figure out what's best for you. And certainly if you have a class, right, you're looking at a class of folks, then some really smart and clever lawyers recently have been bringing mass arbitration cases on behalf of some workers in industries like Uber and Chipotle. They're bringing thousands of cases in arbitration on behalf of individuals, sort of trying to turn it around on the employer to force them to pay the $1,500 arbitration fee, which could end up increasing the amount of damages or the amount of money that they end up having to outlay. But at the end of the day, the reality is that the employer saves so much money by limiting the scope of the arbitration, by limiting damages, by limiting the amount of information that you can get, that really having them pay the $1,500 arbitration fee to go for these 1,200 people is just a drop in the bucket of what they're going to end up saving by forcing you into that really narrow forum. So, I think I think that, sort of talking about a lot of things that Professor Gillis said and Professor Colvin said and Galen said, that all these things should have come together, and you really have to evaluate it from that global level when somebody walks in your office, yeah.
Okay, I want to make sure that we leave time for questions for folks in the audience as well. But I would love to just go down the line quickly and just, we have people that are watching from the live stream today because they felt uncomfortable being seen publicly or because they're part of like temp vendor or contractor companies as well. And so if you could have had one message for any worker out there who's trying to figure out, okay, well, how do I kind of take a stand? What would it be? What would you want them to remember? I want to start with the ACLU side. Here we go.
All right, sorry. Well, one major point is that you can still always bring a charge of discrimination with a state, local, or federal employment discrimination agency like the Equal Employment Opportunity Commission here in New York City. It's the New York City Commission on Human Rights. And those, so it's actually unlawful for an employer to prevent you from doing that. So even if they tried, it would not be enforceable. So you can still go and complain about discrimination to those agencies. Those agencies then still retain authority to prosecute those cases on your behalf or on behalf of others who are in your situation. So that's one place, this sort of safe carve out where the expanding creep of forced arbitration has not yet reached, and the Supreme Court has recognized that those agencies retain that authority to prosecute their cases. And then again, of course, you can always advocate with your own employer and band together, as Tanuja has been so bravely doing with great results. So not everybody can be quite as effective, but I think that it is worth those efforts, and there are some collective action efforts, like some of the law students are banding together to try and get the law firms to stop using arbitration clauses, and they're coming from very elite law schools, starting at Yale, so I think that has gotten some of the law firms' attention. So there are still means of organizing and action against this practice. And then again, there's regulatory and legislative reform that we shouldn't forget, but I'll leave that again to others.
I would say in the employment context, for sure, unionize, and unionize. Banding together for concerted protected activities. Essentially, Tanuja and her group, again, amazing work that they did. It rarely happens that way, that you were able to affect such change in such a short period of time. So testament to you and your peers for that. But organizing, banding together, and essentially forming a union at your employer to be able to press for the change that you need. And within the context of that collective bargaining agreement, you could certainly remove a lot of the impediments that you would otherwise face as a single individual just trying to fight these arbitration clauses.
Yeah, and we do find that there's that real contrast in arbitration between labor arbitration, where you've got a union representing you, and individual forced arbitration, where you're stuck by yourself. The results are very different. One thing that we haven't talked about is that there's another kind of procedure out there, mediation, which is worth thinking about. Mediation is where a neutral is coming in and help you negotiate a resolution to the dispute, and that avoids some of the problems of arbitration, where you get an imposed solution. It's a consensual, negotiated resolution that the third party is helping you get to. If you don't want to agree, you don't have to agree to the result. Sometimes there's concerns, particularly in sexual harassment cases, about privacy in bringing the claim. Mediation is one of the alternatives that can sort of thread a little bit that needle of the legitimate interests of the plaintiff, the victim, in privacy, but also having a chance to resolve the claim. So that is one alternative way to go.
Yeah, one thing that we've alluded to but haven't actually stated explicitly is that to the extent that we want to change the problems that forced arbitration is causing, that a lot of the issues have been litigated. There's been a lot of cases alleging unconscionability and various kinds of unfairness in arbitration proceedings. They've all been pretty much by now ruled out by the Supreme Court. It has really built a wall. It has really doctrinally built just a complete brick wall to prevent or make it impossible to get out from under arbitration agreements if you have one, and also to make it nearly impossible to challenge the results if you go through with one. And so in terms of ending that practice, I think we really do need to think about federal legislation. And there is a bill that was just introduced last month, the Arbitration Fairness Act. A similar bill has been introduced before and got nowhere. But this year, I think for the first time, there's going to be hearings on it. And what it does, what the bill would do, it would be to just exempt consumer cases, employment cases, and civil rights cases from the Federal Arbitration Act. And what this would mean would be that all that law that makes arbitration basically impregnable and unassailable would just not apply in the employment and consumer setting, which would be a tremendous victory. So in terms of what we might do about the problem, I think at this point, it really does mean not just, unionizing and taking action the way the Google workers have and the law students have against particular employers and particular industries is great, both in and of itself, but also because it helps build momentum. And I think that this is one where we really do need to build some kind of public momentum to support this legislation, because all of our civil rights laws and all of our employment laws and all of our consumer protection laws really don't work anymore if they all have to be resolved, if disputes have to be resolved one-on-one in private arbitration.
I don't have much to add. I think they sort of covered the waterfront. I will say I'm testifying on Tuesday before the Senate Judiciary Committee on the FAIR Act, and so I will bring your good wishes. And I think the great thing, we were talking about this before the panel, the great and interesting and weird thing about this hearing is that it's been called by Lindsey Graham, a Republican, who, I don't know what to say about Lindsey Graham. There's so much in my mind right now. But this is a good sign. Last time I testified on behalf of the urging Congress to enact the Arbitration Fairness Act, Franken was the sponsor, and he was sort of leading the charge. Franken's gone for all those reasons. But this is now a Republican majority Senate, and Graham has called this hearing, and it is apparently the first hearing that is a bipartisan hearing. In other words, both sides, both Dianne Feinstein, ranking member, and Lindsey Graham, chair, agreed to have this hearing on this issue. So there is some consensus. So apparently, finally, better late than never, Congress is realizing what I think we have all realized for a long time. The American people really hate forced arbitration, and they want Congress to do something about it, because I think Professor Stone is absolutely correct. We've got to deal with this at a legislative level, right? Dealing with it company by company, hoping for employees to be as brave as the Google employees, or as privileged. Or as privileged as the Yale students. I've been working with the Yale students, future masters of the universe, right? They feel like there's nothing they can't do, and those are wonderful things. But there are lots of employees who do not feel that way, and they're right not to, because they're easily replaceable. Yeah. And so I think that's important. I'll just do one quick pitch for state legislation. So I've been working with a bunch of advocates to try to enact state legislation because we've been worried that Congress has been sclerotic and not doing much and wrapped up in other things. But now that there's no collusion, we can start working on things in Congress. But if the legislation doesn't go through, I think we should all be thinking about the states, and I think all of you who have any interaction with your state reps should be talking to your state reps. State legislation would essentially deputize employees to bring actions on behalf of the state, right? Because states are not bound by arbitration clauses. There's a way in which we could allow employees, individual employees, to bring representative actions that would otherwise be brought by the AG's office or the consumer rights person in the AG's office. Bills are now pending in New York. It's called the Empire Bill in New York. There's a bill in Washington State. Oregon, we are just beginning legislation, the legislative process in Maine. We're getting there in Vermont. So sort of the states I think you would imagine would be interested in doing this, but I think these are states that have recognized that their public enforcers are just overwhelmed. They can't handle all of the complaints that are coming into their offices. They can't monitor every single workplace in the state. So they want to try to use or leverage the private employees to help them at least investigate and possibly bring these actions. So, you know, sort of watch out for those bills and show your support for those bills, because that's another measure that I think could be useful on the employment side.
Fantastic. Okay, are there any questions in the room? And if you're watching on the live stream, feel free to tweet. We are monitoring that as well. We'll take questions. Anyone in the room have any questions? Sure, I'll repeat it for the question.
In the event that Mitch McConnell decides not to bring this to the floor, which is not unlikely, and that the Senate unfortunately doesn't change much the game in 2020. Two questions. One, can a president, let's say not the current, do something like Obama did with equal pay to change this? And the second is, when the Labor Department is not run by a guy who defends pedophiles, could it be possible that like an actual Labor Department person creates and enacts some regulation that also supports employees on that? Or, I mean, what are the alternatives if the Senate is not in the mix?
That's a great question. I'm going to repeat it maybe with a little bit less color than that. Should the Senate not bring this bill to the floor, could a president make a change through some kind of executive order, or could the Department of Labor do something about this?
Well, I guess I'll just, you know the story during the waning days of the Obama administration. He signed an executive order that barred forced arbitration for contractors with contracts with the government. We saw the Department of Education bar mandatory arbitration in those contracts. We saw DOL do the same. We saw the Centers for Medicare and Medicaid do the same. We saw all sorts of agencies promulgate rules to bar or ban mandatory arbitration in the contracts over which they had authority, and perhaps most wonderfully and disappointingly, the Consumer Financial Protection Bureau, after years of study, promulgated a rule that would have did bar mandatory arbitration clauses, class banning mandatory arbitration clauses in consumer contracts, consumer financial contracts. Many of those rules were subject to the Congressional Review Act. So the Congressional, I don't want to give you an ad law primer here, but the Congressional Review Act allows a new Congress to basically, they have a certain number of days to basically repeal legislation or rules that the prior Congress or prior agency had promulgated. And so this Congress did so pretty broadly, and other rules simply died, right? They sort of sunsetted because they were not sort of permanent rules that had gone through the notice and hearing process. So could we see that again? Sure, but I think we should learn from that lesson. To do it earlier, so that it's not subject to CRA, but even maybe executive orders are not the best way to deal with a problem that affects so many people in so many different ways. Perhaps we need legislation. Maybe we need our elected representatives to sort of stand up and say, this is what the American people want. Not just one guy or hopefully girl to say, hey, I'm gonna sign this, look at my cool signature. I'm gonna sign this thing and it's gonna be true for however long it's true, but instead to enact legislation. I think that would be a better way. I think that's the lesson we've learned. But frankly, however it happens, I would be really happy. I think beggars can't be choosers here.
Oh, I am hopeful on the Republican side, because when we were in the Hill last month, I actually heard some really great arguments from Republicans of why forced arbitration should be ending. And it had nothing to do with workers' rights. It was about market distortion and things like that. So we'll see. Yes, go ahead.
Yeah, I don't see this being an administrative solution, because the National Labor Relations Board did their best to try to undo class action enforceability. So I see the only possibility as an alliance between people on blue and red states to get together to try to push this, because it really hurts everybody. And I just can't go through the administrative process again, because I had these great victories that were just swept away with nothing.
So less of a question if you're watching, but more of a comment emphasizing that we need legislative change, absolutely. You had a question, sir? Yes.
Yeah, thanks for a fascinating panel. And very disturbing too,
Yeah.
I must say. As you might be able to tell from my voice, I'm not from around these parts, so the whole thing is quite stunning in some ways. But bearing in mind, there's probably some people from the big end of town who are watching the Twitter feed. But I'm curious as to why it is, well, I've got sort of multiple questions, but first of all, why is it that there's been such a growing impetus in recent years for this? Like, a concept like that doesn't just suddenly become fashionable of its own accord. Somebody pushes it, some interest group or lobbyist association, whatever, pushes it. What explains that big rise in the use of it? The second question is really, what do you want trade unions in America to do? Like the expression of interest, encouraging people to come here seems to be toned into unions, but I'm wondering what is it that you're wanting them to do and that they're doing at the moment, they're not doing at the moment?
Did you get all that audio, Wes? Or do I need to repeat it?
Yeah, you should repeat it.
Okay, so two quick questions. One was kind of, how has this rise come about? It can't just be natural as somebody pushing it. What's the agenda? And then the second question is around, well, what can existing unions do and what their role should be?
Well, let me say a little bit on that, and I think others might add too. A lot of this started in the 1980s with the Supreme Court changing its interpretation of the federal statute. So the Federal Arbitration Act had been a kind of sleepy statute in a little corner of the world in which it applied to federal question cases that were brought in a federal court that it didn't apply to the states, and it was actually used primarily in these kind of industry-specific trade association kinds of disputes. And it was also used in the securities industry and collective bargaining under a different statute. But it wasn't really very visible until the Supreme Court sort of turned that upside down. Why they did that is an interesting question. I think some of it had to do with the ideology of the idea that there's too much litigation, that we have this litigation explosion, we have to get cases out of the courts are clogged, the courts are too expensive, too time-consuming, and so let's find a faster, cheaper way to resolve cases. So I think that was part of it. But then it sort of picked up some momentum, and some of the conservatives got on board, and Scalia got involved in some of these cases. And also some elements of the business community started to say, hey, this is a good way to solve some of our problems with class actions. Because class actions became really a major threat to American businesses, both consumer class actions and employment class actions. And it became really a huge issue because the damage awards were huge. You know, if you're cheating everybody out of $25, if AT&T is, and they have 2 million customers or 20 million customers, that's a lot of money that they're going to have to pay out, not to mention lawyer fees. So I think that, and there were actually groups within the business community that actually came together to really try to change the law and make it even so they changed the law so that the federal act would apply to the states. Then they changed the law, this was a huge important thing, so that it would apply to statutes. Originally, people thought it just applied to contractual disputes. You have a contract, you're supposed to buy and sell something, and you get the good, and it's not at the level of quality you expected, and you could go to arbitration to see if the quality, comports with the contract. But to arbitrate statutory rights, that was really a big deal. That started in the 80s with the antitrust law, with the RICO law, with the securities law, but then we start getting employment statutes being subject to arbitration. So it really was something that really took off in a big way starting in the 80s, but really in a much more visible way once the Supreme Court upheld the class action bans and also made it absolutely crystal clear that despite the language of the statute that it applies to workers.
And just to follow on with that, I think part of the story that follows on from that is from the employer side, that they were really reacting to this expansion of individual employment rights. If you look at the kind of history around that time too, this 1990 was the Americans with Disabilities Act, 1991 a real strengthening of the Civil Rights Act, Title VII of the Civil Rights Act, 1993 the Family Medical Leave Act, and that was a period when EEOC complaints were going up substantially in the 90s. They actually kind of level off in the 2000s as arbitration picks up. And then in the 2000s, you see wage and hour cases, particularly class actions in the wage and hour area, really picking up. And so I think part of the story is that employers are getting more worried about employees getting more individual rights, and this is a way to push back against that litigation. And then on the second part of your question, the union part of the story is interesting, because part of the reason that individual employment rights are a bigger thing is because unions shrunk in terms of the number of workers that union protections. And the unions didn't respond to this, to be frank. I'm very supportive of the labor movement, and this is one of my criticisms of that they have not been very active until very recently on this issue. For a long time, I think they sort of were complacent about it. They said we have other problems. They did have a lot of other problems to deal with in terms of employer opposition to unionization. But it's only been recently that we're starting to see some parts of the labor movement start to say, wait a second, this is the flip side of the same struggle for worker rights and fair resolution of workplace disputes that we've been fighting for a while. And it's still, I think, the case that the labor movement could be doing more in this area as part of these political coalitions around this issue that I think are building. I think the Me Too movements had a lot to do with getting this on the front page, but there are, I think, more and more groups, even consumer groups, nursing home residents are often affected by this, and this is a group, and advocacy groups for the aged have been really starting to look at this issue, and I think there is a growing coalition building around this.
Yeah, absolutely. Any other questions in the room? Yeah, go ahead.
It seems like there are two issues that you're all identifying. One is the idea of confidentiality, that all of these agreements have to be confidential, so the average worker who wants to be able to say Me Too and appear on cable news or write an op-ed and say what happened to them can't. So that's one issue. And then the other is this class action ban that's also wrapped up in the same arbitration clause. So I'm wondering if you think there's any more likelihood of Congress addressing one or the other, or do you think that they either both are going to happen or neither will happen, or should maybe activists focus on one or the other?
Yeah, just quickly summarizing your question for the live stream. So there are two issues that were kind of teased out here. One is the gag rule, or the confidentiality rule that comes with these arbitration agreements, where you can't talk about it, so it's really hard to say Me Too if you're bound by that. And then the second part is the bans on class actions. So the question is really, do we have a better, more strategic chance if we tackle one area as opposed to all of it together? Does anybody have any thoughts?
I mean, I will say, I'm not sure I know the answer there, but I will say there have been sort of parallel pushes in the wake of the Me Too moment we're having to think about ways that we could shine a light on systemic harassment that's happening within perhaps a particular company. So obviously the Weinstein scandal was really buried because all of the women were forced to sign settlement agreements that included a confidentiality provision, a non-disclosure agreement that was very strict. And so nobody knew, it was not coming out into the public, and that has been true of repeat harassers in companies where these individuals are perhaps, kind of rainmakers within their company, and the employer wants to protect them, and therefore, they're not really held accountable. So there have been efforts to think through ways to increase reporting of those types of complaints. There have been proposals to mandate reporting to the EEOC, if a company receives a harassment complaint, things of that nature, so that at least the agencies would be in possession of some aggregate data on the scope of the problem. So that's one initiative. I don't know that they've been necessarily viewed as either or. I don't really see them as linked because efforts to reform the arbitration process are really just creating a carve out for the types of cases, for particular types of cases, and the confidentiality provision would go with that because they would then be allowed to go to open court. I don't know if others have.
Yeah, I would actually just want to say one thing that, so Google's policy, we did not have a gag order. You were allowed to talk about your proceedings and what was happening to you, but you still had to go through arbitration, which is bullshit at the end. We're in New York, no one cares. It's BS at the end of the day, right? Because it's really impractical. And so I would hope, I don't know about strategic advantage, but I would hope that we fight for the full thing at the end of the day, because they will just get around it in one other way. So that would be my personal push.
Let me make another point that Tanuka just brought to mind, which isn't exactly responsive to your question, but is that one of the things that these arbitration clauses do is that they also suppress claims, that people don't bring claims that they otherwise have. For one thing, and Professor Colvin's research has shown it's very difficult to win in arbitration if you don't have a lawyer. Okay, and lawyers won't take a case unless they think that there'll be reasonable damages at the end of the road and a reasonable chance of recovery. And so, but it's also been shown that individual workers don't win as often in arbitration, and when they win, they don't win as much in arbitration as they would in court. And so lawyers are very reluctant to take the cases, and without the lawyer, you can't win. And so a lot of people don't bring their cases. And one of the newer trends, which is even more damaging or suppressing of claims, is that in some arbitration agreements, and I think it's spreading, but we don't know for sure, is a provision put in there that whoever loses has to pay the other side's costs. Loser pays. And so now let me back up and say, even without that, it's more expensive very often to go to arbitration than to go to court, because in addition to having to pay a lawyer, you often have to pay the fees of the arbitrator, which are not trivial. But now these loser pay clauses mean that people really are rolling the dice if they take a case to arbitration, because they don't know if they'll win, and they could actually be ending up paying the other side's fees and lawyer costs. And so it really is about claim suppression as much as it is about diversion of claims. And so this gets back, I think, in some ways to the question, because I don't think the carve-out for one type of claim really is the answer. It's good, and it's a partial answer, but all of our labor and employment rights and all of our consumer rights are really withering because we don't have a robust way to enforce them.
Just to touch on that for a second, and back to the gentleman's question in the back, sort of why is this happening? Another, I think, snapback from what the employment laws did, which is fee shifting, or so if you bring an action, or in many of the employment statutes, you can get attorney's fees if you prevail there. I think what a lot of the employers saw was that they could force these provisions within arbitration agreements on you that say the exact opposite, or sort of you may fee shifting in an employment case in federal court, the plaintiff's attorney is going to end up getting the attorney's fees in that case, but the defendant's attorney does not get their attorney's fees if you end up losing. They saw this in arbitration. They said, you know what, we can put this in the contract because we can really realistically put anything in the employment agreement that we want, the arbitration agreement that we want, right? It's just the arbitration, the concept itself is just derived from that agreement. So, sort of reach for the stars. Whatever you generally want to put in there, is generally being upheld these days. So if you want to put in there that loser pays, then loser pays. And that's a way for the employers to, what they would say, level the playing field, but the rest of us would say suppressing claims and suppressing worker rights.
Do we have anything on the Twitter feed? Okay. Yeah, go ahead.
Yeah. What procedures would you change, either with JAMS or AAA or all these other arbitration forums, to make the process more fair?
question for the live stream was, what would we do to make arbitration more fair?
So one thing straight up, they could say, we're not going to arbitrate a procedure that includes a class action waiver. That is something that they could actually do, and I think that would have an effect. So that would be one of the things I would put right at the top of the list.
And they briefly did, do you remember? I mean, Jan's briefly said, we're not gonna touch an arbitration clause. It's okay, I can yell. I'm a law professor, I can yell. So Jan's briefly said, for like a minute, we're not gonna actually touch an arbitration clause that has a class action waiver because we think there might be fundamentally unfair, a violation of public policy. It lasted, what, a week? And they realized that all of their clients on retainer were like, what were we paying you for?
Yeah.
So these are for-profit companies, these arbitral providers. These are not public courts that are subsidized with our tax dollars. So when we ask questions like, what can they do to make it better, you got to think about what side their bread is buttered on. They want to continue their roster of very fancy companies who pay them, retainer fees and, who knows what else to keep them on board. So I don't know that there's any way that a pre-dispute forced arbitration clause that contains a class action ban should ever be arbitrated by these companies if they take seriously what the concept of arbitration should be. So I actually really reject the idea of adding window dressing, Band-Aids to current arbitration. They have due process protocols. It doesn't matter because, as Kathy says, nobody's bringing arbitrations. So, and they're not bringing arbitrations because they think, oh, the process is unfair. They're bringing arbitrations because they're not bringing them because they're expensive, because they have to do them alone, because they can't get a lawyer to do it for them, because there's nothing in it for the lawyer. So there's nothing to make it better. What we should do is get people back into court where we can see what's happening and where companies will actually know that what they do is the stuff of public record.
Let me just add one more thing to answer your question, just one more thing. One other thing they could do that's even more extreme maybe than what was just suggested is they could say they won't do pre-dispute arbitrations. They will do post-dispute arbitrations. Because what we've been talking about in the forced arbitration concern is when you're going into a relationship and it's imposed on you, and you don't have a dispute yet. You don't know what the dispute will be about. You don't even conceive that you'll have a dispute. You wouldn't take the job if you thought you'd have a dispute. You wouldn't buy the product if you think it's going to blow up on you and blind you. So you don't think you have a dispute going in to the relationship, and yet that's when the clause is imposed. On the other hand, if instead they would administer post-dispute arbitrations, that would be once you have the dispute, you could decide, do you want an informal, more relaxed, perhaps more expeditious procedure, or do you want a full-blown litigation? And at that point, there'd be no problem with these providers then providing arbitrators at the post-dispute level, in my view.
Did you have a follow-up?
So I was just going to say that for all of the employees that are still subject to arbitration, will litigate in arbitration, in forced arbitration, while at some point we will get to the point that it's banned. But until that point, many individuals are stuck with potentially one deposition, limited discovery, but there are measures that can be taken to make that, to level the playing field.
So one thing I would sort of add on that is who the arbitrators are. Right now, there's no regulation on who can be an arbitrator. And I think that's one of the really fundamental problems. We talk about the arbitrators, as some kind of amorphous mass. These are different individuals. They might have affiliations with kind of one side or the other. And so, I think it's an unregulated profession. We wouldn't let we don't let lawyers just anybody say they're a lawyer or a doctor. These are people making really important decisions. We used to trust the parties to pick the arbitrator, but here one party didn't get to choose to be in the procedure, and I think that changes the whole calculus. We need to be thinking about who these individuals are and regulate them.
Yeah, and I think that you're not going to change the fundamental underlying scope of discovery and the process itself. You're not going to really change the way that the case is handled, just because that's not what arbitration is. It really is just supposed to be very expeditious, minimalist proceeding, right? So that's not, you're really not going to, you're going to change the entire industry if you're going to try to change that. What I would like to do is sort of lift the veil. Private arbitration decisions on, the actual underlying cases themselves. There's some state laws across the country where, California specifically, you have to report certain things to certain departments. But in, particular cases for employment context or even consumer context, what are the issues at hand? How did the arbitrator rule? What was the evidence there? I mean, if you want to know how to prosecute an employment case, you go to Westlaw and you find out, right? You go there, you know what the actual facts are, you can figure out exactly what was brought, what was the evidence in support, what were the damages at the end of the day. You don't really have that so much in, depending on where the state is and depending on the arbitration, the arbitrator himself or herself. A lot of the arbitrations settle, actually I think it's a 70% or something rate settle. So, at the end of the day, I'd like to know more about that process, what goes on in there. I'd also like to know more about how that arbitrator rules, right? I mean, you have 100 employment cases before that arbitrator, maybe they rule 98 against 2, right, for the employer and against the employee. Maybe if you're going to bring a case to try to overturn that arbitration in federal court, afterwards you can show arbitrator bias in that case. You're not getting that now. So, sort of shine some light on this process would be very helpful. I don't know if anybody thinks that would ever happen, but I think that would be very helpful.
Could a state, for instance, come up with legislation that says that the money that's being paid for the arbitrator should not come from a specific employer, but be like in a pool of money?
So the question is, can the money that pays for the arbitrator not come from the employer, but come from maybe a neutral pot of money?
I would say that that would likely be preempted under the FAA under current law, right? Because the Supreme Court has taken such a broad perspective on what the parties have agreed to in the arbitration agreement, and that, that would affect that the parties said to each other, are forced on one on the other, the entity is going to pay, or we're going to split, or so on and so forth. I think the court, and I'll look to others, I think the court would come down and say, no, the parties agreed to it, we're deferring to whatever the party said. Sorry.
But I think that the question and some of the comments raise this this problem of potential bias amongst the arbitrators, especially those that are repeat players and have big companies as their bread and butter. And there's even a further twist to this right now, which is that some of the arbitration service providers that are for-profit have arbitrators who are shareholders. So they actually have an interest in keeping the repeat player big clients of the arbitration service by making them happy, even if it's not their own personal case, but they want all the cases that involve AT&T that their company arbitrates to please AT&T. And so there's a case right now in the Ninth Circuit that will be argued this summer that involves a disclosure where the plaintiffs are at least trying to get the arbitration service provider, which happen to be JAMS, to disclose which of its arbitrators are shareholders, so that that level of financial interest in the outcome would at least be evident at the point where the parties are picking the arbitrators. So they can, at the moment, there's no obligation to even disclose that kind of information.
We'll take a few more questions. Were there any on the, we're good? Okay, great. Let's go to you real quick, then you, and then we'll come. I know you, so hold on. Go ahead.
You had mentioned some state laws that have been proposed. I saw news coverage of a law passed in New York State last summer that supposedly prohibited forced arbitration in cases of sexual harassment. Can you talk about that and how it relates to the federal law and the federal court rulings?
The question is about New York State law. Yep.
Yeah, so, and this is, I think, the Me Too movement doing some good work here. So New York State and a bunch of other states, but I would have to get back to you on the exact number, enacted legislation barring companies from forcing claims of sexual harassment and sexual discrimination into arbitration. And Congress has considered, I think Kirsten Gillibrand is a sponsor of a bill that would have done the same thing. Gretchen Carlson, who was a Fox News personality, who had an arbitration clause, sort of famously breached her clause and sort of, raised this question and was on Capitol Hill a lot last year, sort of arguing that this is the sort of thing that has to be made public. And I think one of the things that's interesting is that, these sexual harassment claims feel like to lots of people, well, that's public, we should know that stuff. It's not just happening to this one woman. Likely if it's happening to this one woman, that means there's a cover-up and it's happening to lots of other people. It means that there's an environment, a culture, a norm in the workplace that's allowing this to happen. And that's not just the stuff of one person's claim, that's the stuff that we should all know about. And I think that's great, but let me just put in one sort of negative view on that, which is the Swiss cheese approach to fixing this problem has been going on for decades, right? We've seen Congress enact legislation that tells us that military personnel who are, serving overseas, whose homes or property are subject to repo claims, that they can't be forced into arbitration. We've seen that car dealers, of all groups, I guess they have incredible lobbyists, car dealers can't be forced into arbitration. Very independent military contractors, sexual harassment claims against military contractors can't be forced into arbitration. That's the Franken Amendment. It's very narrow, and it makes it feel like a certain group got to a certain legislator and made something happen. And I just think that's gross, right? Because the truth is, sexual harassment claims are a real problem, right? I think they suck. But so do lots of other problems in the workplace. So is sexual harassment more important than wage theft? I'm not prepared to say that, right? So I think these laws are a good sign, and they were a great moment for educating legislators, right? Because it was a lot of campaigning around this that was great education for legislators. But I really think a sort of broader look is important, and not feeling like, oh, I've solved that problem, because I think the problem persists.
But just to be clear, the New York law is clearly preempted by
right.
federal law.
Yeah.
It's not enforceable.
It's not.
So unfortunately, some of the state legislators, I think they've done something, which, yeah, they've sent the right message, but it's not enforceable. I mean, there are certain things you can do at the state level. The President Gills mentioned the public attorney general type actions. That can work. Better public enforcement of employment rights would actually be something that you can do at the state level. Put in place a better state public enforcement system. I think the government has advocated the idea that there's a public responsibility to ensure workplace rights, to ensure that we have public agencies that have the power and the resources to take action where there are violations of workplace rights. One of the things that we've really seen from the Me Too movement is that these problems exist in workplaces all over the place. These conflicts are real. We're not in sort of, even great companies like Google have its problems. And, conflicts need to be resolved fairly. We need to have our worker rights protected.
Yeah, absolutely. We'll take 2 more questions, we'll wrap it up. Go ahead.
Thanks, sorry to take up your time again, but it strikes me that you've got sort of a bipolar model here, which is either you have private arbitration, which is basically run by the companies, or you have the courts. And the problems with one is that it's rigged in favour of the companies, and the problem with the other is that it's massively expensive, and that's what led to its decline anyway, at least according to what you were saying earlier. But there's like an intermediate model which you see in some countries, which is basically publicly provided arbitration services. And we've had that in Australia with what's now called the Fair Work Commission and various other bodies dealing with other things like consumer law and so on. And there's the Conciliation Arbitration Service in the UK and so on. And I wonder whether part of the problem with getting the Republicans' support is that, there's a certain group of people who they want to provide support to, but the thought of a high-cost model like the courts is really scary to them. And the publicly funded arbitration system, there's still basically a low-cost model. It's not entirely in favour of the workers, it's got lots of problems, which I could talk for hours about, but it's still probably got fewer problems than either of the other 2 systems that you've got in place at the moment.
We recap that as well.
So the question is, why not go towards some kind of more public system that's kind of in between, that maybe we have a sort of simpler, more accessible system that arbitration is supposed to be, but in the forced arbitration context doesn't really provide, but also doesn't have the high costs of the court. And many other countries do have these kind of systems. Canada's a human rights tribunal system. Australia has this fair work system, a public commission. The United Kingdom has an employment tribunal and also system, and also arbitration conciliation service, the public service. We could certainly be thinking about that, and I think that's been a real failure of American public policy in this area, not to think about alternatives. The one thing, though, I do think that is still important and is a valuable thing in the American court system is, yes, it's a high-cost system, but what it does that no other system does is, in really egregious cases, serve this signifying public function of saying certain things are really egregious behavior. You get the large damages, and yeah, they seem outrageous in certain cases, and you get the sort of war stories of the burnt coffee and so on, which is actually a pretty bad case when you hear about what actually happened. But there are really egregious cases of sexual harassment and other civil rights violations out there, and the fact that in the US you can get 10, 20, 30, $40 million damage awards really does serve a disciplining effect on employers. You get better employer practices because of that. So, I mean, I would be totally in favor of a public alternative system that's available to all workers, but I think retaining the ability for those really serious cases, that if you wanted to go to court and get that jury of your peers saying this is really egregious, we got to punish that, I think that is an important American value that I'd like to keep.
Yeah, I'll just add that the EEOC exists in part to serve that function here. It's just completely underfunded, and so you are required for employment disputes under particular civil rights laws, including laws prohibiting sex and race discrimination on the basis of national origin and religion. You have to go to the EEOC first before you can go to court. You have an administrative exhaustion requirement. And part of the function of that, the purpose behind that, is so that some of the disputes at least can be worked out through the EEOC process. And they do offer mediation. The EEOC will offer mediation to the parties in certain cases. So it exists, it's just very small. It's not up to the job. And there are similar bodies for other types of disputes as well. Public entities that are charged with doing that type of informal pre-litigation dispute resolution with varying degrees of formality. So they exist. It hasn't been a public policy goal or commitment that's been made to robustly fund them such that they could really do that work in an effective way. And so that could be a shift, that could be a policy shift toward that might serve the same function without the need to create a whole new body. I'm not sure that it covers the waterfront of different types of disputes already, but there are at least places you can go for employment cases and to a lesser degree, I think, labor disputes. So.
But I think actually it would require a culture shift. I think our laws are premised on the idea that public enforcers are going to, private enforcement is going to complement public enforcement. And so I think we would actually, I agree it's been a failure, but I think it's because we come at it from a very different perspective in this country. So whether right or wrong, right, that's the way our laws are drafted. And I think that's the way that our public enforcers' budgets are created, right? This idea that there will be supplemental ground support through litigation and through private litigation. So I just feel like the whole thing we'd have to really change our perspective in a big way to get there. And I'm not sure that's where we're headed.
Yep, okay, we'll run out with the last question.
So let's say I'm a relatively responsible business and I'm using arbitration because it's easy and I'm risk averse. Is there something you could say to me so that I'm supporting ending forced arbitration, or at least not standing in the way of ending forced arbitration?
The question is, how do you appeal to someone who is maybe a small business owner or relatively, responsible business owner who doesn't want to take on that risk, but how do we appeal to that person?
Well, I would repeat what I said a few minutes ago, which is I would urge you as a responsible business owner to end pre-dispute arbitration and adopt a system of post-dispute arbitration and perhaps devise a good system, a system that is actually selects neutral arbitrators and gives people discovery and gives people various kinds of due process along the way, but make it an option when you have a dispute. And that way you get the benefit of the informal mechanism in some cases, but not all. But if you design a good procedure, people may choose it, but you're not imposing on everybody this pre-dispute trap that ensnares so many people.
That's actually the perfect way to close out the panel tonight, because the question is, what can we do next? And the federal legislation that was introduced a month ago is the Forced Arbitration and Justice Repeal Act. No one is saying, let's get rid of arbitration. We're saying, stop making it forced. Let me choose. And so I wanted to just alert you that, there is a Senate hearing on Tuesday that will be there. And then Friday, for those who are on Twitter or kind of tuning in right now, we are launching the Fair Act Friday campaign on Friday, where we'll be telling stories every 15 minutes from 9 a.m. to 3 p.m. of people and what they've experienced as they've gone through arbitration. A lot of times the only time you find out somebody went through arbitration is because they tried to file a suit in court and then the company compelled them to go into arbitration, right? And so now you're like, well, what happened? How did we find out? And so we'll be telling those stories, and so you can hear firsthand what happens to those folks. So if you have questions, continue. If you're here in New York, there's lots of food and wine, so please drink and eat. If you're on Twitter, eat and drink too, and look up more about arbitration, and thank you.